probably have some idea. I was asked to come down and talk to this class as part of your law program, but also as part of their project in the block. So today we're focusing on one particular area of the law that I don't know how much involvement you've had to this point, and that is family law. It's an area of the law that perhaps is the busiest area outside criminal law that involves the courts. The courts are busier with family law than anything else except criminal law. So what you're getting today is an opportunity to hear a little bit about how things work in the court system related to family law. And I'm looking for a lot of input and questions from you guys as we proceed through this. I'm hoping that there's lots of ideas that you can come up with that will help us lead this conversation today. I don't know how long you want me to go. So we're going to talk about family law, and for those of you who don't know what family law is an area of the law that relates to children and their parents. So it can be, some people will simplify it by saying that's divorce law. It's not only divorce law, okay? It involves all kinds of other things, such as parents' ability to manage growing children. It involves things like the choice of children being removed from homes. There's all kinds of options within the family law system that the courts address on a daily basis. One of the big things, though, that we talked about when it comes to preparation for today was to talk about the area of family law that relates to children. And in New Brunswick, there is one overriding issue that the courts address every time that children are involved in the court system. Anybody have any idea what the one overriding issue for the courts in New Brunswick in particular is when it comes to children? So the terminology that's used, not only in New Brunswick, but in other provinces as well, is considered to be best interest of the child. So whatever's in the best interest of the child is what the court will order in any single family law issue. Okay, that is how they think. Their plan is, as a judge, to find what's in the best interest of each individual child and to make their order related to that interest. So I want you to be thinking here over the next 5 minutes or so about how that can work, how you would come to a conclusion as to how you serve the child's best interest. And in case you're interested, you are still a child in New Brunswick until you reach age 19. It's not 18, it's 19 in this province. So even if you are 18 and out of school, you are still a child and are still considered, under the law of the province of New Brunswick, to be somebody that is under the tutelage or the observation or the responsibility of their parents. Okay? So as a child in New Brunswick, and you all would be classed as children in New Brunswick, what do you think are the most important things for you, for a court to think about when it comes to your best interests? And you may want to think about how that would affect you, the kinds of things that a court would need to think about, why a court would think about those things. Okay? So I want you to keep that in mind over the next couple of minutes, because I want you to come up with some questions for me that are going to drive that issue. So I want to be able to go do a lot of question and answer with you here this morning. Family law is not an area that I have a lot of expertise in. Okay? Most family law practitioners tend to be very much specialists. They do family law and only family law, not much else. I was not a family law practitioner. I did do some family law over the course of 25 years of practice, but it wasn't an area that I specialized in. So my family law experience is pretty minimal. But at the same time, that doesn't mean you don't know what's happening in the family courts in New Brunswick. So I have some idea of how those things work, and I have a good sense of the types of things that the court considers when making decisions. In the same way that I was not a family law specialist, often judges are not family law specialists either. The way the court works in New Brunswick is that family law falls under the Court of King's Bench, which is the higher court in New Brunswick. And those judges are appointed from a wide variety of practitioners. So in most cases, those judges are chosen from lawyers that practice in other parts of the province in various different areas, physical areas, and in different types of practice. So you may choose a lawyer who has spent their life primarily doing criminal law to be a judge in the Court of Queen's Bench, who may then spend the rest of his career on the bench doing family law matters. Okay, so he may be someone who has done very little in family court, but is assigned to that area because they may be a better choice than the guy who spent his life doing property law or wills. Okay, so the courts make those calls. And not only do they say, okay, you're coming into the court, you're going to be a judge in our court, you will only always ever do family law from now on. Sometimes that same judge that does family law may do a murder trial somewhere else. Okay? So judges are not necessarily only pigeonholed in one area. They try to keep them in their areas of expertise, but they're not always successful in doing that. So remember that judges have various experiences, personal experiences. They have various experiences in practice, and they have various experiences behind the bench in courts. So those all play into the issue of best interest of the child. Okay? Anybody got any thoughts here on what sorts of things a judge would be considering when it comes to a child's best interest? What do you think? So certainly child safety is a prime issue when a court is considering what kinds of things need to be done. And in many of these cases, probably 90% of cases where we're talking about these issues, it's issues of divorce or separation within a family. Okay? So that tends to be the main focus for these court cases. And the judges are required to look and say, okay, what is the best interest of the child when it comes to issues like where the child is going to live? How is the child going to get access to both parents? Where is the child going to go to school? Who's going to make the decisions on the child? Who's going to be the one that decides whether the child gets braces or doesn't? Okay? So those are all issues that the court needs to think about when it comes to best interest. Certainly the child's safety, though, is probably the single highest interest that the court has. Best interest of the child, obviously, if the child is going to be unsafe, that's never in the child's best interest. Okay? Yep, Caden. Guardian income is an issue. So the court is going to take a look at the parents, and they're going to say who is in the best position, in many cases, to provide the child with the necessities for that child to live. They don't always say the parent or guardian with the largest income is the one that the child will live with. That's not the only factor. There are a whole number of factors. And one of the things that you need to think about is that this decision by a court is entirely subjective. Okay? It's not an objective decision. They can't say that he makes this much money, she makes this much money. They live here, one person lives here, one person lives here. It's X kilometers to the school, multiplied by 8, and there's the answer. You know, this is who they're going to live with. It doesn't work that way. They look at all the factors associated with time in court and what the child needs and what the child might need. It's not just what the child needs today. It's what the child's going to need for the next, if they're 12, the next 7 years until they turn 19. So those are all considerations that the court has to have, but certainly income is a factor, okay? And remember that in many cases the court may equalize income between the parents in those circumstances. If the court sees it that it's important for one parent or the other to have custody, the court may say, well, we're going to give custody to the parent who has the lesser income, but the parent with the greater income will have to contribute child support in the other direction, those kinds of things. They'll also consider whether or not what the likelihood is of the person being able to pay child support. It will depend on their own personal circumstances in many cases. Yep. Yep. Mm-hmm. It would not. Yep. It would not happen often, because normally in that circumstance, what would happen is the court would say, okay, the custodial parent, the parent that was not working, who's going to have custody of the child, the court would normally impute income to them. In other words, they would say, you don't have a job right now. If you're able to work, and in some cases, if someone is unable to work, that's a different story altogether. But if you're able to work, and you have chosen not to work because you were a stay-home mom, for example, and that's, I don't necessarily want to place gender roles here, but that's traditionally, that would be the issue. A stay-at-home mom, the dad worked for a company for several years. The dad brings in the majority of the income. The mom stays at home and raises the children. Traditional 1950s family, okay? Not that it's an untraditional family today, but that would be a traditional 1950s family. So in that situation, the court would say to the mom, okay, you need to find work. You need to go out and work and contribute to this, because you can't rely solely on the other parent to provide for you at this stage. And the court would be reasonable in saying within a reasonable period of time you have to find something, and maybe would depend on that person's ability to find a job, the location. So for example, here in Miramichi, until maybe a few years ago, pre-COVID, there weren't a lot of jobs for people. So in many cases, that particular parent may have difficulty going out and getting a job. So the court would have to consider that. Is it reasonable to expect her to find a job in an area where there aren't a lot of jobs? If the couple is in Iqaluit and there aren't a lot of jobs available, then the court's going to think differently about that than if they were in downtown Toronto, where there are lots of jobs available. And then ultimately, if a period of time goes by, let's say it's a year goes by and mom still hasn't got a job, the court is then going to say, okay, mom, we're going to have to look at adjusting the amount of support that you're receiving because you haven't actively gone out properly and found yourself a job. There should be something out there that you can do. And the court would look at all the factors, because in many cases, childcare is a floating thing there, and a childcare can often cost almost as much as the mom might earn if she went to work. So the court would consider all of those factors, and it would be the mom's responsibility through her lawyer to show the court, this is why I haven't got a job. This is why it doesn't make sense for me to work, because my expenses would be so much greater. I have transportation to and from work, I have childcare, I have clothing for work. Those are all expenses I would have, and in the end, there would be no benefit to doing it. So that becomes her responsibility through her lawyer to prove to the court that that's necessary. The age actually does have a substantial effect. What the courts have determined is that young children especially need their mom. So when it comes to a decision on custodial parents, the courts will often say, there's no direct line there, but younger children, specifically younger children under school age, for example, the heavy emphasis would be on providing a way for that child to be with their mom. And that's simply, for some reason, I guess the courts still believe, as they have for years, that is an important factor, that children, that moms are more geared toward raising children than dads are. We all know that may or may not be the case, but that's the way the courts look at those issues. The other issue is then at that age, at school age, the courts would say, well, mom may be less necessary, and therefore maybe we'll adjust how the children spend their time. Maybe it becomes a 50-50 split as opposed to an 80-20 deal or whatever. So yes, age is a factor all along. And then, of course, as you get older, as the children get older, age becomes an even greater factor, because ultimately the children have a say, right, in what they're able to do. When they reach a certain age, the children are consulted. The court may ask for the child's input on where they would like to be and what they would like to do. And that may be, many children might say, well, look, I want to spend half my time with my mom and half my time with my dad. In other circumstances, that may not be the case. So usually by the age of about 14, the child's own decision would be the most important factor for the court to consider, as long as they were satisfied with the child's safety. And then it would become where the child wanted to be. Unfortunately, that often leads to issues of children picking and choosing where they think they get the best deal, right? So if mom is a little more strict than dad, then it's pretty easy to say, yeah, I'd like to live with my dad. He's not as strict as mom is. Of course, they don't tell the court that. I want to live with my dad. And it turns out that, of course, dad allows the child to be out later at night, or bedtimes are not quite as set, and those kinds of things. So oftentimes it leads to one playing off against the other. And the courts are usually careful about that, but they're also not in the business of regulating what children decide to do. So, once a decision is made, a decision is usually made. Doesn't often get revisited unless there's a major change. That's right. That would be a significant one, especially today. That's a greater issue than it was 20 years ago, certainly. Addiction issues are a significant factor, and it gets around to the safety of the child as part of that, right? Because addiction issues can affect children in many, many ways, but one of the ways that it can affect children is the addict's inability to properly supervise the children. And if that's an issue, the question that leads to a child's safety, then certainly the court would be all over that. Even if it wasn't a safety issue, it'd be hard to find a case where an addict's children where that wasn't a factor, there wasn't a safety issue. But even beyond it being a safety issue, there are other issues. The child's ability or access to their parents' behavior, and whether or not that could lead the child to look in that area. So court would make that consideration. Is this a factor? Is it likely that if a parent is addicted, that a child falls into addiction as they reach a certain age? What's that? Yeah? Where the child support money goes. So it sounds like a really difficult question. It sounds like one of those things that every court should be pondering over and over and over. What do I do with the child? How do I order the child support money to be spent? And in reality, what happens is the child support money gets spent whatever way the parent that receives the child support money wants to spend it. Okay? There are no court restrictions placed on what they have to do with that money. Once the court decides that someone is entitled to X number of dollars in child support, then the receiving parent can spend that money in whatever way they see fit. It's interesting, though, that child support in itself, the amount of child support, is the one area that is not subjective at all. It is completely objective. There is a chart. Father makes X number of dollars, or mother makes X number of dollars. They're going to pay child support for one child, two children, 3 children, 4 children. Go across the list. That's the number. That's how much you pay in the run of a month. So those things are very categorized. There's absolutely a specific number that applies to parents with income at a certain level, and and the number of children. And it's just a matter of following the chart. One of the very few things that the court doesn't really have a whole lot of input in. The court will make the decision based on those numbers unless there's some drastic reason to change that. But primarily, the court will go by the chart. And if the chart says it's to be $1,200 a month for 3 children, then it's $1,200 a month for 3 children. That's the way it works. And in that case, the custodial parent makes the decision on how it's spent. What other factors? There are lots of them. Yep. They do at a certain point, and there's no hard and fast rule. It used to be around age 14 that the child would actually testify in court and say, this is what I'd like to see. But now those numbers are dropping. So the court may even consider a child's wishes at the ages of 10 and 11 now. The older they get, the more influence they would have on the court. So those are factors that are considered. Age is always a factor, and not only age, of course, but level of maturity. So the court would want to interview the child to have some idea of how, and when I say the court, I mean the judge, would want to interview the child to see how mature that child was, the reasons for the decision they were making. You know, if they actually told the judge, well, the reason is Dad lets me stay up later, chances are that's not going to be something the judge is going to consider. And in fact, it may mean the judge doesn't think about what the child has to say because they know they're not mature enough to make a real decision. So that interview that the judge has with the child, and I suspect that interview would happen any child over the age of 10, would play a role in the decision that the judge would make. Other factors, ability of parental guidance to the child. So are you suggesting like if parents were both working extra hours and a whole lot during? Yeah, you know, if one parent worked 60 hours a week and the other one worked 20, then the court might be more willing to say, well, you know, this parent has more time to spend with the children, and therefore the children would go there. And the other parent would provide child support because they work more. That is a possibility. And again, how that would affect the best interest of the child could vary from family to family. So, yeah, but certainly that is a factor. Any other thoughts on other factors that could affect a court making a decision on best interest of the child? Yep. Absolutely. Absolutely. Cultural and religious factors are also part of what the court looks at. So the court may look at parents who perhaps each practice a different religion and have to make a decision on how the child spends their time. The court won't make a decision on, they won't tell the parents that a child has to practice a particular religion. Okay? They won't say, you know, your child is going to follow the religion of your mother, and therefore, you know, your father can't talk about religion with the child. That won't happen. But the court certainly could look at the family dynamic and say, okay, we want to be sure that cultural and religious issues are both recognized. So, for example, if one parent was Indigenous and the other was not, in many cases, the court would require the non-Indigenous parent to provide some detail as to how they would ensure that the child's Indigenous culture was maintained if they were to be the custodial parent. So those are significant issues, and ones that courts are not afraid to talk about. Yep. That's a huge one, actually. Where the parents live is a massive factor in determining where the children would spend the majority of their time, for a number of reasons. First of all, where they live could determine opportunity for the child. So, for example, even though it may sound unfair, living 25 kilometers in the woods may affect somebody who's age 14 pretty dramatically, where if the other parent lives in the city limits, there may be more opportunities for the child. There may be more negative opportunities for the child as well, But a court will look at that and say, does that make sense? If the child, especially if the child was hesitant to do that, to then say, okay, we're going to require that you spend the majority of your time, you be the prime custodial parent, on the farm with no friends within any particular distance. That would be unusual for the court to make that order. Normally, a court would then try to find additional time for that child to be with their parent that lived in a larger area. And also there's proximity to each other. That's a factor the court will look at when it comes to determining how much time or how regularly the children see the non-custodial parent. So when I say custodial parent, I mean the one who has primary custody of the child, and the other would normally have visitation or access, it's referred to in the court here, child access. And it would seem to make more sense if the parties, if one lives here and one lives in Richibucto, then maybe the child would spend the week with the custodial parent, let's say it's here in Miramichi, and maybe every weekend with the non-custodial parent in Richibucto, or 3 weekends out of 4, or something like that, with the non-custodial parent, rather than a night on, a night off, a night on, a night off, because the distance makes it a little more difficult. The further the distance, the more the court has to spend time thinking about how that can work, because it's extremely difficult to factor in all the possibilities that could result. For example, what if the parents ultimately choose to live in different countries? How does that work? How is a court going to resolve that issue? We all hear stories of parents, even within Canada, that choose to move to another province. And oftentimes, this is a big country. So moving to Ontario is not like a weekend thing. You don't get to see a parent on a weekend if one lives in London, Ontario, and the other lives in Miramichi. So those are all factors that the court has to pay a great deal of attention to, and then to make a decision, because ultimately one of those parents is going to be the custodial parent. So the court has to decide, okay, I'm going to, maybe the dad moved to Ontario, I'm going to give custody to the mom, and the dad is not going to see those children as often as maybe he wants to. That's a hard call to make for a court, a really hard call to make. One of the reasons that I chose not to do family law is that I didn't want to deal with that kind of thing, not from the judge's side, but even from the lawyer's side. I didn't want to be the guy who was going into court and asking that somebody not see their children. I just found that was too difficult, so it wasn't an area that I wanted to do. Yep.
What about step-parents?
Step-parents are a factor. Maybe not a huge one, surprisingly. The court tends not to think about step-parents. Certainly, they're not a factor when it comes to the financial issue, because again, like I said, child support is a cut and dried issue. It's a chart and you pay it, and it doesn't matter if the other spouse is remarried or has a step-parent, or that step-parent could be loaded. Doesn't matter. The one who pays the child support still pays the child support. That doesn't have any effect at all on child support. It's not family income, it's parental income. So if the stepdad, for example, makes $300,000 a year and mom makes $0, and the actual dad is paying child support, he's paying that child support in the full amount. Regardless of how much money the new stepdad makes. That's just the way it works. So, never a factor. At that point, oftentimes the courts will rely on the parties to have some common sense. So they'll hope that there are people within the grouping that, if they don't hate each other too badly at this point, are prepared to say, look, I don't need that much money because, we're doing well financially. You don't count on that, but the court can often hope. Yep. Yes. And often, Nell, that would be a situation where the call was made by the other parent. So in other words, if you were going to court to talk about the issue of child custody and visitation, then the parent who had the problem with the step parent on the other side would be expected to raise that to the court and to provide some evidence as to why maybe it would not be a good place for the children to be on a regular basis, that kind of thing. But absolutely, that all plays into that safety of the child issue. Yeah? Normally not. If it's not brought up by one parent, there wouldn't be, I guess nobody's going to bring it up, right? So if one parent doesn't know that that other partner exists, certainly the one who has the other partner is probably not going to raise it if they think there's any issue at all. So the court wouldn't even know in that case that there would be another person there unless somebody brought it up. So there would be no independent investigation by the court to make that call. Anytime you appear in court, it is still an adversarial situation. So even if the two parties get along, adversarial means that one side competes against the other, right? So the situation is that in order to be successful, you have to win. You win in steps necessarily, not necessarily you win the whole thing, but you win steps. And if you hope to prevent the other party from having custody or to limit their custody, you have to still prove your case. You have to show why you should limit custody. What else? What else is a consideration?
Where they work.
Where the parents work? Yeah. So for example, if one parent works in northern Alberta and is only home for 1 week every month and is away for 3, certainly that parent could not be expected to have full custody of the children, and the court would be, in that case, prepared to adjust visitation or access so that that particular child would be able to see that parent when they were home. That's the kind of adjustment a court would make, and that would be seen to be, the court will always see the best interest of the child as having access to both parents on a regular basis, unless there's some reason why they're shown that the child shouldn't have access to both parents. So again, it's a factor of one side saying, no, this child shouldn't see his father or shouldn't see his mother, and this is the reason why, and here's the evidence to prove it. That's the kind of situation that arises. Yeah. Yes, a criminal record might play a role in a situation where those criminal records pertain to something that would potentially endanger a child. And I'm thinking of, we can take a look at some of the more common things. So you have a DUI. Well, somebody has a DUI, you question, would they drive with a child in the car when they were intoxicated? That goes back to an addiction issue, right? So there's a question of whether that flies there. Simple assault or something like that, depending on the circumstances of the assault. Somebody punched somebody in the nose in a bar fight somewhere, probably not going to have a great deal of effect on whether or not they're suitable to be a parent or suitable to have regular access to their children. So I think it depends on the particular circumstances, and again, it would be up to the other party to prove that, to bring that up, saying, I don't want my children with him because he has a record of this, and this, right? So, yeah.
What happens if the parents disagree what's best for the child?
Then the judge makes the call. It's that easy. If the parents can't come up with an answer, then you go in, you have a full-blown trial, and the judge listens to all of that evidence. All of the things we've talked about become a part of the judge's consideration. And ultimately, the judge's decision has to affect both parents. They have to live with it. So parents are always better off if they can come to a deal that works between the two of them than they are to let a judge make the decision. Not only for the reasons that are quite obvious in that you don't get to make the call, the judge is doing it for you, but also because there's a substantial cost to getting to court. So you incur that cost, you pay a lawyer, I don't know, $10,000 to go to court, and you know, in the end, somebody's got to win and somebody's got to lose. Somebody that paid $10,000 is going to lose. So, you know, you're going to pay $10,000. You go to court. You don't get what you want. The other parent gets full custody, and so that's probably not the wisest thing to do. You're probably better off statistically to try to find some medium ground, unless both sides, and quite frankly, it happens. But unless both sides hate each other so much, they can't possibly come to an agreement. I've had situations in past cases where people fought over the fridge, like seriously fought over the fridge. Threat to go to court over the fridge. You know, those are the kinds of issues that can become major problems, because in that particular case, one of the adults involved claimed that their parents had given them the fridge, so they felt they should be entitled. And the other party said, no, we bought the fridge, so I should get it. And literally, they were almost ready to go to court over the fridge. Everything else had pretty much been resolved. So, you know, $5,000 to figure out who gets the $2,000 fridge. Any other thoughts on, yep, no?
What would happen if like one parent can't afford a lawyer or can't afford legal expenses and the other parent can? That puts them at a disadvantage.
It does. In New Brunswick, there is some limited legal aid available for family law. It is, however, very limited, and it depends absolutely on the circumstances of the parent. So if the parent was not working or had a very low-paying job or worked part-time hours, that sort of thing, there may be some legal aid available to help. And legal aid in New Brunswick, and this may have changed in the last 10 years, I'm not sure, but normally family legal aid in New Brunswick does not have their own lawyers. Legal aid, there isn't a legal aid office where you walk in and a legal aid lawyer sits you down and does work with you. There is for criminal law, but not for family law. In family law, what happens is legal aid agrees to pay your lawyer of your choice X number of dollars to handle a certain case. The problem with that is legal aid pays a very, very low rate. So in a lot of cases, the lawyers you're getting may not be the best lawyers, okay? And not that doesn't necessarily mean that you get a bad lawyer. It just may mean you get somebody who's maybe not as experienced as some others, that sort of thing. So, but legal aid is available in some very limited circumstances. Yep.
Parent has any sort of illness?
Yes, that would be a factor. If one parent had, especially if they had a debilitating illness, would be a factor when it comes to what's in the best interest of the child. So, for example, if a parent had some illness that required them to be in a wheelchair, for example, maybe they couldn't supervise young children as well as others might, depending on their mobility and things like that.
Sounds like that, like BPD or something.
Sorry, that's a...
BPD.
Yeah, that could be a factor. You know, a mental health illness certainly would be a consideration, but again, it's one of those issues, remember, that the other side has to bring up, right? So you're not going to put your hand up in court, and it's not like when parents decide to separate and divorce that the court sends out an investigator on both sides and tries to find all these things. What happens is one side is required, if they want to win, remember, it's all about win and lose. If one side wants to win, then they have to find the reasons why the other side should lose. So that could often become a factor if it's raised, and then maybe the court would do a little inquiry. They would just ask for a couple of witnesses maybe to talk about a mental health illness perhaps and how that might affect the children. So certainly it could be a factor, but it would have to be raised by somebody. That would be a pretty dirty thing to do, to raise that, unless it was really, really a significant issue. Any other thoughts on items that might affect the decision? Yep, no? Mm-hmm. Depends on which one of the parents gets to the court first. And really that's all it is. And the reason for that is in Canada, if you file for divorce, for example, or you can take steps prior to divorce to just answer issues of child custody and support. But if you file for divorce, there's a central registry in Ottawa. So what happens is when you file in New Brunswick sends a report to Ottawa and says, this person's filing for divorce in New Brunswick. Have they filed anywhere else? Or have these two parties filed anywhere else in the country? And 99 times out of 100, the answer comes back and says, no, this is the only one that's filed, or you filed first, and therefore everything takes place in that province. So if it's New Brunswick and Ontario, for example, you file for divorce in New Brunswick, everything happens in the court in New Brunswick. So even things down the road, when it comes to a trial, it would be in New Brunswick. It would not be in Ontario, even though one parent may be in Ontario. So that's a jurisdictional issue, and that happens with a lot of different things, actually. And there are certain requirements for jurisdiction for filing lawsuits against people and things like that. Depends on where the event happened and where the parties live and all those kinds of issues. Yep. Yep. Any other thoughts on what other things might affect the decision of the court when it comes to best interest of the child? Yep.
What if the child disagrees what's best?
The child's opinion would have an effect, but not the final effect. So, in other words, if the child disagrees and the judge says, no, this is very definitely in your best interest, the judge's decision rules. Okay, so the judge ultimately is the one that makes the call, even if the child doesn't like it. And oftentimes that is the case. The child doesn't like it. The judge's opinion is the one that, as Judge Judy says, my opinion's the only one that matters. That's the judge. Any others? We're just about through our period, so I guess we got about 15 minutes left, but we did pretty well. Anything else anybody wants to ask? Doesn't have to be family. I guess the answer is there will always be a best option. There may not be a good option, right? So the court will almost always find the best option, even if it's a bad one, unless there's some reason to feel that neither parent is appropriate for custody. And in that case, unfortunately, what happens is then the province steps in, and there would be a request for an order that the child be placed in foster care. So obviously that's an extreme that nobody wants to see that happen. And there's always a best option. So if there's still no danger imposed on the child as a result of that best option, the court will take that. But often there is no good option. Any other questions? And again, it doesn't have to relate to family law. If you want to ask just a couple of general questions, that's fine too. I'm here. Yeah. Okay. That's it. We're good.